Thank you, Nelson. Our next speaker this morning is Lindley Jones. Lindley handles serious personal injury, wrongful death cases that involve brain and spinal cord injuries. She has over 20 years' experience representing clients in hundreds of serious personal injury cases around the United States in both state and federal court. She's AV rated from Martindale-Hubbell. She's the only plaintiff's lawyer in the greater Atlanta area who's board certified in the field of legal malpractice by the American Board of Professional Liability Attorneys. She's the first woman in the United States to achieve this board certification, and she's one of the few lawyers in Georgia with extensive experience in legal malpractice cases involving the negligence and misconduct of lawyers and other professionals. She's going to be speaking to us this morning about avoiding legal malpractice at trial.
Thank you. Thank you for having me. Thank you for that kind introduction. Good morning, everybody.
Good morning.
All right. I've been doing legal malpractice and personal injury now for about 22 years. I have a lot I want to share with you today, so I'm going to put my watch right here on the podium so I don't talk too much. All right. It is not your imagination if it seems to you like there are more frequently legal malpractice cases filed against lawyers in recent years. That's a fact. There's been a recent poll of insurance companies, that is insurance companies that provide professional liability insurance, and they estimate that in the past couple of years, the incidence of legal malpractice claims has increased by 20%. And I can tell you that in the past 20 years, it's increased far more dramatically than that. Basically, the cat is out of the bag. People now know that lawyers are responsible for their negligence just like everyone else. And as a result of understanding that lawyers are responsible for their negligence, and as a result of understanding that there are remedies for that and they can bring suit if necessary, I believe that's the reason why the claims have been on the rise. I don't think it's a result of any increase in people committing legal malpractice. It's just an increase, I believe, in people seeking recourse for legal malpractice. But that being said, it used to be that trial lawyers and litigators were at the top of the list for who was at risk of a legal malpractice claim. Well, since the recession, beginning in about 2007, that's no longer true. And that's the good news for trying cases and jury trials. The number one area at risk for a legal malpractice claim is actually real estate and real estate lawyers, followed by business formation, mergers and acquisition lawyers, securities lawyers, all as one group. Those lawyers are in second place at risk of such claim. And thirdly, lawyers who do wills and estates. So trial lawyers are no longer even in the top three groups at risk of a claim. Nevertheless, it's important to make sure that you're doing your best to avoid a claim, and more importantly, doing your best to avoid the kinds of mistakes that give rise to claims, which is really the point of my presentation today. Because, in fact, most of those insurance companies that I referenced earlier attribute the increase in legal malpractice claims not only to the factors I discussed, but also to the increasing number of conflicts of interest that go unidentified. Those are primarily in larger firms. It is far more common nowadays for firms to merge and for lateral hires to occur. And when those things happen, it is not unusual for the folks at those firms to fail to recognize conflicts of interests. And so that is the number one source of the claims, is conflicts of interest that go unidentified. And those happen certainly in the trial and litigation context too. And we'll touch on that. Failure to know and or properly apply the law is the second most common source of legal malpractice claims, followed thirdly by missing deadlines. And that includes the statute of limitations, but it also includes answer deadlines and all sorts of other deadlines. That's the third most common overall source of legal malpractice claims. However, in my experience, with primarily litigation-based legal malpractice claims, that's actually number one, is missing deadlines, improper calendaring, failing to answer, those sorts of things. But the good news is we have a unique protection in the law as litigators and as trial lawyers, and that is judgmental immunity. Judgmental immunity is the doctrine that holds that there can be no liability for acts and omissions by an attorney in the conduct of litigation, which are based on an honest exercise of professional judgment. So you have that discretion, and you should feel confident in exercising that discretion in making tactical decisions about your case. And that's a term that's been used time and time again in the cases that interpret this Allen decorating case, tactical decisions. In making those tactical decisions, you have immunity. You can decide, based on good reasoning, sound reasoning, what witnesses you want to call, what evidence you want to put on, and what you don't want to do in your trial. You don't have to put everything up because you're concerned about malpractice. Even when your client wants you to, you want to try to help your client to understand why you might not put all of the evidence that might potentially be presented in a case up. But you do have immunity, judgmental immunity, for those decisions. When malpractice occurs in the context of a trial, in my experience, it occurs primarily as the result of a failure to prepare. And so I want to give you 3 tips about avoiding malpractice in trial preparation. First of all, subpoena all your witnesses. Now, that may go without saying, but maybe not really, because when you have a friendly witness, when you have an after-the-fact witness or a family member or someone that has been right there for you and the client throughout the case, and you just have no question in your mind that they're going to appear voluntarily, maybe you don't subpoena that person. But you need to subpoena all of your witnesses, because in the event that they do not appear for any reason, intentional or unintentional, unavoidable, you are going to need to rely on the fact that you did subpoena them, that you did pay them their witness fee. The witness fee is mandatory, the mileage is not. You must have filed that subpoena with the court in order to ask the court for a continuance or other relief based on their non-appearance. So that's why I think it's important to subpoena all of your witnesses, even the friendly ones. Of course, you need to make sure you have all the documents necessary to prove your case, and that's my tip number 2. Just make sure you have all of your documents necessary to prove your case, and that those documents are admissible, and that those documents are admissible under the new evidence code. And then thirdly, I encourage you to focus as much on substance as style. And trial lawyers, we tend to be performers, and we tend to want to focus on the performance at trial, the way we're going to present the case, how we are going to persuade the jury, and all of that is terribly important, and in fact usually crucial, but none of it matters if the I's are not dotted and the T's are not crossed. And there are so many instances in which it appears to me that a lawyer has delegated, or I learned that a lawyer did in fact delegate critical trial tasks that had to do with the building blocks, the fundamental building blocks upon which their case was going to be based at trial, delegated them to associates or to staff members and relied on that delegation. Now, of course, we know that lawyers are responsible for any negligence by their associates or by their employees, and so it gives rise to that liability. But the concern's not liability. The concern is just doing a good job and making sure it's taken care of. So I encourage you to focus as much on the substance of what you're going to present at trial as on the style and the persuasion and whatnot. But let's take a worst-case scenario. And let's say you have, in fact, made a mistake that has cost your client their case or cost your client money, despite your best efforts. Well, that's what your insurance is for. That's what your professional liability insurance is for. And should that happen to you, I encourage you not to panic, but to turn it into your insurance company just like you would an automobile claim if you accidentally rear-ended someone. It's not what you would intend to do, but maybe it happened despite your best efforts, or maybe it was a moment's inattention, or maybe it was just your humanity, that you made a mistake. So, you turn it into your insurance carrier. Unfortunately, there may be issues with insurance, and this is so important that I want to share this with all of you today. Professional liability insurance is not what it used to be. You've got to do more than purchase a policy and pay your annual premium to make sure you're covered. And it is, it's devastating to learn as an insured person that you have paid your premiums all those years and you didn't understand how your coverage worked, you didn't have enough coverage, or you did something that caused you to lose your coverage despite all of that. So let me just warn you, first of all, there are a shocking number of uninsured lawyers in the state of Georgia. A shocking number. There are no records kept, so I can't give you a percentage. But I can tell you that it is not unusual for a lawyer to be uninsured. This is something that you should take into account when you make your referrals. Because if for any reason you are held jointly liable for something with an uninsured lawyer, well then all of the liability would fall on you. And under the ethical rules, when you make a referral, you still technically share case responsibility. And that can translate to liability. So you want to make sure lawyers you refer to are insured. This is not so much an issue if you're referring to a firm of any size, because they are nearly always insured. But with solo practitioners, they are not necessarily. And so that's something for you to be aware of. I want to warn you about a problem with professional liability policies that most folks still don't know about. Insurance companies know about it, and they're taking great advantage of it to provide less protection and limit their costs. But there are policies out there, in fact, I don't know a percentage, but most policies out there, the vast majority of policies out there right now are diminishing limits policies. And what that means is that the lawyer who is defending you in a legal malpractice claim, their bills, their expenses are deducted from your policy limits. That's super important to understand. It will affect your ability to defend yourself from a valid claim, because legal malpractice defense lawyers, I've got to give them their due. They're great lawyers. They represent lawyers for a living. They're great lawyers, and their rates reflect it, maybe $400 an hour or so. So you can imagine how quickly very, very large bills can be incurred. And at that rate, it is not unusual if a case goes to trial for $1 million or more in attorney's fees to have been incurred by the time the case goes to trial, by the time it's approaching trial, not by the time trial is done. And sometimes those fees are incurred much, much earlier. That means exhaustion of your policy limits. They have no incentive not to bill, and they can exhaust your policy limits. Now, that does sound like a conflict of interest. That's something that I'm asking the bar to take a look at right now, because as lawyers bill for their time, they're exhausting their own clients, the insured's ability to pay the claim. But as of right now, these policies are allowed, and the vast majority of them exist. So protect yourself. This is the language that you're looking for in your own policy if you don't know the answer to what I just said with some degree of confidence. And frankly, I would not rely on an agent or a call to the agent to find out if my policy is diminishing limits. There are policies out there that are not clear. I sat down with a lawyer yesterday at lunch who brought a policy to lunch. We were coincidentally having lunch, but she had the policy. She said, "Is this diminishing limits or not?" I read the thing 3 times, and the language was such that it was very difficult to discern. And the defense counsel did not agree with the insurance company about whether it was diminishing limits. But the standard diminishing limits language is clear if you read it. It's generally on the declarations page of your policy. And it's that little blurb at the top that a lot of people don't read. You go straight, you say, okay, there are my policy limits. There's the 1 million, 2 million, 5 million I wanted to make sure I had. And you just look at that and you make sure the deductible's right. But right at the top of that declarations page, one of those sentences may say what it says right here: the limits of liability available to pay damages or settlements shall be reduced by amounts incurred as claims expenses. You would then have to check to understand that claims expenses includes attorney's fees. So that's the language you want to be on the lookout for. If you have a diminishing limits insurance policy, there are only 2 ways I know of to address that. And maybe some of you might be more creative, but the 2 ways I can think of are: you can increase your policy limits to allow for at least $1 million in attorney's fees to be taken out while you still have adequate coverage for whatever you need to have covered. So if you actually want to have $1 million in coverage, you can increase your policy limits to $2 million, and you're probably pretty safe with that. There will be some increase in your premium. It is not as dramatic as you might think. The second way you can address it is by asking for a CDOL rider, which means a cost of defense outside limits. And those are not cheap. Several $100s at a minimum, sometimes up to a couple $1,000s to get them to write the claims defenses outside of your policy limits and to pay them outside of your policy limits. But those are the only two ways I know to address that. The reason that this, I believe, is not more well known is that these policies were not widely written until 3 or 4 years ago, and they became popular virtually overnight. So people who have just renewed their policies may have at some point had this language slipped in there and not realized that their policy that previously paid attorneys' fees now has a diminishing limits policy. All right. Another concern with professional liability insurance is that carriers are increasingly looking for any way they can get out of covering claims. And so if they decide that they have some basis, any basis, upon which they may deny coverage for a claim that a lawyer has submitted, they will send a reservation of rights letter. And a reservation of rights letter is a letter in which the insurance carrier informs the insured that they are going to provide a defense, but they're reserving the right to challenge coverage. Some carriers are now issuing these letters as a matter of course every time they get a claim. So should you get a reservation of rights letter, don't panic. It is often used as a tool to negotiate with the claimant so that they can tell the claimant, you better settle this claim for X amount because this lawyer might not even actually have coverage. But as the insured lawyer, the toll it takes on you to have your carrier question whether you have coverage is tremendous, and I think that's a very unfortunate tactic. But you can count on a reservation of rights letter if you have a claim against you that goes into litigation. The number one basis for a denial of policy coverage in a professional liability policy is failure to timely report a claim. This, too, has evolved. It's evolved in such a way, not surprisingly, that it benefits the professional liability carriers. They have created such a tight limitation on reporting the claims that there's a huge pool of cases that they can challenge for failure of lawyers to timely report the claims. So let's talk about what reporting is, let's talk about what a claim is, and what timely reporting is. In many insurance policies, if not most, the insured, that is us, has a duty to report a claim immediately. And it used to be that you had a reasonable time to report a claim. There is still some case law out there that, despite that policy language, allows you a reasonable time to report a claim. But the policy language most frequently nowadays is that you must report a claim immediately. And that, of course, is a very high standard for the promptness with which a claim is reported. And the definition of a claim is tricky. That immediate reporting requirement usually is not problematic where a lawyer gets a communication from a client that the client is bringing a legal malpractice action. Most lawyers recognize that as a claim. They report it immediately to their carrier. And that is one definition under the definitions clause of most insurance policies of a claim, is that you are notified by a client that they are bringing a legal malpractice claim. Okay. But the second definition of a claim usually goes something like this: when the insured lawyer becomes aware of specific circumstances which could reasonably be expected to give rise to a claim. That's incredibly broad. That could encompass virtually any negative action in any case. And it's that language that is used against insured lawyers when they go to make a claim against their professional liability insurance. There is a way to handle this. It used to be that it was really not necessary to report a claim unless you had what we traditionally think of as notification of a claim. Now, I strongly suggest that you report to your carrier any negative incidents, and you can do so with most carriers by reporting an incident without reporting a claim. And regardless of how they characterize it as an incident or a claim, it generally will not affect your premiums if there's no follow-up action or if nothing ever occurs. You report it for your own protection and that of your client so that that insurance is available later. So if you have an incident and you believe it may be curable, but if it's not, there's going to be a real problem in the case and it's going to affect the value of the client's case, then I encourage you to report it to your carrier as an incident, and you will protect yourself without having any significant adverse circumstances from doing so. That being said, declaratory judgment actions to avoid coverage are on the rise in legal malpractice cases. Probably 50% of the legal malpractice cases in which I was involved last year also involved a declaratory judgment action by the carrier to deny liability. And again, I believe that to be, to a large extent, tactical, a way of holding down the value of claims. But that's no comfort to a lawyer who perhaps did not report a claim under this broad claim definition quite as promptly as they wish they had. And it's not just trial lawyers and litigators and even real estate lawyers and estate lawyers who are subjected to claims anymore. There's a new field that did not previously exist of claims being brought by banks and insurance companies against their lawyers. And really, for the first time, defense lawyers are facing significant risk of legal malpractice claims. In that regard, it is most frequently defense lawyers who draft the releases that are used in cases. And for so many years, it was common to use certain form releases. And I can just think of, the tens of thousands of claims with State Farm that used exactly the same release language every time. And because of that frequency and reoccurrence of the same form releases over and over again, it can be tempting to not pay as close attention to the language of a release as one should. The clause in a release that broadens the released parties to include heirs, successors, affiliates, associates, etc., that clause can release all sorts of unintended folks. And every time you read it, be careful about who in that particular instance might be released and from what. I was involved in a matter last year in which tens of millions of dollars in debt were released for parties related to the released party because that language was so broad in a release. And it was just done out of a lack of due care and a lack of analysis of exactly who was being released. Similarly, you have to be certain to release everyone who should be released, because last year I was also involved in a case in which there was a long, hard-fought mediation and resolution of a case, and when the release was drafted, the individual was released. But not all of his corporations were, and the plaintiff came back subsequently and sued one of the corporations. So be careful about the parties who are designated in a release, that they include everyone who should be released and no one who shouldn't. Let's talk about litigation. When you enter into ongoing litigation, there's a particular risk of malpractice that doesn't exist when you have had the case from its inception, because there have been things that have gone on that you just can't know. And so it takes a heightened level of involvement right out of the gate when you agree to get involved in ongoing litigation. And one thing I want lawyers to know is that you are required by the rules to enter an appearance in ongoing litigation within 48 hours. That's been the rule for many, many years. There was a time when it wasn't as critical because things did not happen as quickly in cases, but it is critical. You must enter that appearance within 48 hours of agreeing to represent a client. And that's whether the client was previously pro se or whether they were represented by a lawyer. I had a case just recently in which a lawyer failed to enter an appearance within 48 hours. During that 48 hours, notice of a hearing was sent out. The lawyer was not aware of the hearing because the entry of appearance had not been made. A default judgment was entered against the client, and the lawyer was fully responsible for that default judgment, although the lawyer had done everything else that would have been appropriate in the case. That situation could have been avoided, number one, by timely filing an entry of appearance, but it also could have been avoided by checking the online docket, not just once, but more than once, because of the newness of the case, and checking it, for example, when the contract was signed with the client, and then perhaps a week later, until you know that you are on the court's radar, that the clerk has picked you up as a lawyer representing a party, and that you will be receiving the notices you need to receive. Fast forward to preparing for trial. There are many different methods that lawyers use to prepare for trial. Nelson Tyrone before me touched on methods that he uses to prepare for trial. I myself use a trial memo, and I've attached that to your materials, a copy of the trial memo that I use, and perhaps it's something that will be helpful to you, or certain things I do to prepare for trial that are listed on there may be helpful. I also do a pre-trial conflicts review, and I make it an item on my trial memo because circumstances can change over the course of litigation. So if you have more than one party that comes into your office and retains you for representation in litigation, and at that moment there doesn't seem to be any conflict, that is something that should be revisited as you enter into trial. Sometimes it can become much, much more obvious as you prepare for trial, because there may be questions that you would ask one party about the liability of another party, or about their actual level of involvement in the incident and so forth, that you decide not to ask because you're representing both of them, and, well, you wouldn't feel right about doing that. Well, if that's your answer, then you've got a conflict of interest, and that analysis should be performed pre-trial every time you're representing more than one party in litigation. That is an area that is just ripe for claims. Nowadays, almost all of our cases are electronically docketed, and it is the goal of the State Bar of Georgia to have all 159 Georgia counties on electronic docketing and electronic filing within the next couple of years. So that will then conclude and end all paper filing in the state of Georgia. And there are some new considerations in light of the electronic e-filed cases. I want to share with you one case that really highlighted that and that suggests some solutions. The case is Blackburn versus United States Department of Agriculture Forest Service. And in that case, a plaintiff filed suit for negligent failure of the Forest Service to control what was supposed to be a controlled burn, and it got out of control. It burned over $500,000 worth of the plaintiff's property. The plaintiff filed suit. Plaintiff didn't hear anything to speak of for 6 months until they got wind, no pun intended, that their case had been dismissed because they had failed to respond to a motion to dismiss in federal court. Why had they failed to respond? Well, they looked back, and it turned out that the email address that they had used to file it, or that a staff member had used to file it, was an email address that went to an email box that wasn't frequently checked. It wasn't commonly checked, and so they had simply missed subsequent filings. And so they thought, well, that's a terrible thing, but we'll get this straightened out. We'll ask to have it set aside on the basis of excusable neglect for our electronic error. Well, the court declined to set aside the dismissal. The court said that is not excusable neglect. And the court gave a list of things that the lawyer should have done had they not been neglectful, that would have allowed them to learn that this case had a pending motion to dismiss, if nothing else. And the list is daunting. Because if you see here, the district court asked, why during those 6 months didn't the plaintiffs call the court to check on the status of the case? How unusual would that be? That's completely unheard of that you pick up the phone to check on the status of your case by calling the court. So I don't agree with all of these, but this is what the district court in this case had expected the plaintiffs to do. They asked why the plaintiffs didn't visit the court in person to look at the case file. Well, in an e-filed case, of course, nobody does that either. They asked, and I enjoy this one, why they didn't call the opposing attorney and ask what was going on in the case. Now, I can only imagine the reaction they would get. I don't know that opposing counsel would have said, well, I filed a motion to dismiss, right? But that was what the court thought they should have done, that they could have called the U.S. Attorney's Office. They could have called the judges' chambers to find out the status of the case. And finally, why they didn't check in with the PACER system, which is the only one of those seems logical to me. Nevertheless, the point is, I think, that so much time had elapsed in that 6 months that the court found that it wasn't just the wrong email box problem that was neglectful. It was the failure of the lawyers to follow the case. And my takeaway from this, from my personal practice, was that in my electronically filed cases, I need to check their dockets every 30 days, even if I believe I'm getting all the emails. Because I don't know about you, but I've had the experience of emails disappearing into the abyss. There's just no explanation once in a blue moon for where an email has gone. So checking the electronic dockets in your e-filed cases every 30 days to just read through it and make sure nothing's happened that you are not aware of for any reason because it's sitting in your junk email box, you accidentally hit delete when you didn't know it or any other reason. And that's my takeaway from that case. Another risk of all of the electronic case handling involves email. And email is just fraught with so many issues and opportunities to botch things up. One of them is, and I always think back to when communications with opposing counsel were by written letter. It was virtually impossible for those written letters to be written to the wrong person. You'd read the letter probably 2 or 3 times, checking and rechecking it. Your staff members reading the letter, addressing an envelope, putting it in the mail. It became pretty evident if the letter's written to the wrong person. But that is not true with email. And this is just the example to demonstrate the autofill, or autocomplete as it's called, when you're sending an email. At one time in my career, my paralegal had the same first name as my sister, and from time to time I'd email one or the other with an inappropriate communication, telling my sister what I expected to have her do at work. But I'm sure we've all had this experience. It autocompletes and you hit send. So I just urge you to be particularly careful about autocomplete because I read a case out of San Francisco in which the lawyers really learned the hard way about autocomplete. This lawyer was representing some engineers from an engineering group called Arcadis, and these engineers had left Arcadis and formed their own engineering firm. And their engineering firm, they were suing Arcadis, and Arcadis was suing them, and they had a big dispute going on. Their lawyer was sending them communications that included the lawyer's impressions and included, even at one point, a draft complaint and some requests for input. And the communication, and it wasn't getting any responses, but would talk to the clients on the phone and say, oh, you're not getting my emails? Okay, well, I don't know what's going on. Finally, they figured out that the lawyer was sending the emails to their old email addresses at Arcadis using autocomplete. As it turned out, the lawyers at Arcadis were not only taking the emails and reviewing them, but they were forwarding them to their lawyers at Gordon and Reese. And they had known exactly what the plaintiff had planned for months and months. And when the court found out that this had gone on, the court sanctioned to the tune of $40,000, guess who? The lawyers at Arcadis. Which is a little ironic because it was the former engineer's lawyer who had actually sent the communications improperly. You wouldn't want to be in either one of those positions is the point. So be careful about autocomplete. And also bear in mind that email is part of the client file, and if you do ever have a claim brought against you, your emails about that case will be subject to discovery. It is so much easier to talk about cases in a casual way in emails than it is in other forms of written communication. And it is not unusual for me to get emails involving a case that are really quite embarrassing for the defendant lawyer and the staff. I had one in which the contention was that certain claims had not been vigorously pursued on my client's behalf, and I got the emails in, and there was actually an email from the lawyer to the paralegal saying, if you'll get this case settled, I'll get you a margarita tonight. And that was, of course, Exhibit A that we would have used at trial, but that case wasn't going to trial because of that email primarily. And that's just one example, but those are the kinds of communications that can occur by email that just wouldn't be written down in any other format. So be aware that your email communications concerning a case are part of the client file, and you and your staff members should be educated on the importance of professionalism in emails. I even created a memo for my staff about attaching items to emails, and I included that in the appendix if you want to share it with your staff. When we attach a document to an email, I require that the attachment be put on the email first before the email address is, to avoid the silliness of sending an email that says, please see attached, and there's nothing attached. We all know that that can happen pretty easily. So I tell them, put the attachment on first before you ever write the email or address the email. And after you put the attachment into the email, crack it open from where you've just put it to double check to make sure that what you are sending is what you intended to, because in this drag and drop world, it is just too easy to drag and drop the wrong thing. And you can compromise attorney-client privilege in the same ways the Arcadis engineering lawyers did. So that memo's available for your use as well. Now, I want to go back to talking about trial and evidence at trial, because we have new opportunities when it comes to trial evidence and how to present our cases, particularly in personal injury cases. We no longer, since last year in the passage of the new evidence code, necessarily have to put on videotaped evidence of doctors testifying with opinion testimony about causation and whatnot in personal injury and other cases, because this new evidence code, this statute that I have before you, 24.8.803 subsection 6, allows medical records to be admitted pursuant to proper certification, which we'll circle back to, and allows the opinion evidence contained in those records to go out with the jury. Now, that's the big difference. Previously, you could admit medical records as business records with proper certification, but you could only have certain information contained in them, and you couldn't have necessarily hearsay, opinion evidence, causation evidence, and all of that in the medical records. Now, all of that is admissible if they're properly certified. So you want to make sure that you use the proper certification form for getting these records in as business records. It's a little bit different. A little bit different than it used to be. And it's a little bit daunting, because the old school way of doing this, and many times you'll still depose a doctor and videotape the doctor, but the old school way of doing this was that you go to trial with your videotape or your CD, and you know what you have on it, you know you have the evidence you need, and you know it's admissible, and all of that's been hashed out when that generally pre-recorded testimony was taken. Now, if you have that critical causation testimony or that critical diagnosis testimony or any of the other critical testimony that can be contained in medical records, you must have the proper certification, and you must be ready to lay the foundation properly. But then you have this wonderful resource that is much more efficient for proving, and particularly in more modest cases, items concerning medical condition, opinion, diagnoses, without having to call a doctor. So it's a terrific new statute, and just be careful with it. Another great tool for us when things do go wrong is dismissing and refiling. Dismissing and refiling is always an option to cure or fix a serious problem that cannot otherwise be cured or fixed. Just a few caveats about it. First of all, you've got to make sure the case hasn't been previously dismissed and refiled. If you're not the first lawyer on the case, you really need to check in every way possible whether that case was previously dismissed and refiled, and not just with the client, because the clients don't always know. That's particularly true in cases involving the use, medical malpractice cases and other cases involving the use of 911 9.1 affidavits. If there's any deficiency in the affidavit, that's one circumstance in which a lawyer may promptly dismiss and refile a case, perhaps not even with the client's knowledge. And if that in fact occurred and then you later enter an appearance in the case and dismiss, that is a second dismissal. That's dismissal with prejudice. That's it. Case over. So you always want to make sure that hasn't occurred before. And I give you these caveats based on things that I see in my practice occur. You also want to be sure that you understand the definition of the same case, because it is the same case that cannot be dismissed and refiled more than once. The same case means the same parties. I mean, it does not mean the same parties. The same case means the same facts. It does not mean the same parties. And that's terribly important for you to understand, because you could have a case in which you sue Party A and you can't get service, or for any other reason dismiss it. You sue Party A again, and Party A says, oh, we weren't actually the ones that owned that facility where your client fell and got injured, or whatever this case may be. That was actually Party B. And so then you dismiss Party A again and file against Party B. Well, unfortunately, that second dismissal of Party A was a dismissal with prejudice. It was a final resolution of that case. It is the underlying facts that determine whether it is the same case, not identity of the parties. And that is a lesson that has been learned the hard way in cases that have just recently gone up to the Court of Appeals. All right. It's important to understand that if you're going to dismiss and refile a case, service of process needs to have been good before you dismiss, if you are going to rely on the renewal statute to extend the statute of limitations. If the reason you're dismissing is because of untimely service, or if for any reason service wasn't made on any party, you need to get that party served and then dismissed, and then dismiss the case. But you've got to get them served first. And then, interestingly, the fact that service on them was not timely cannot be raised in the refiled case. So don't worry about the fact that it's been 6 months, 9 months, 12 months since they should have been served. Just serve them and dismiss, and then you can refile subject to all the other requirements of the renewal statute, which of course include you must pay the costs in the first case before you can refile. Now this is an interesting one, because paying the costs requires that the clerk tell you what the costs were, and oftentimes the costs are zero. So you may contact the clerk and the clerk says there were no costs in the first case. Well, okay, but you want to have something to prove that, because you don't ever want a different story to come out or a different clerk to decide there were costs. So you need to get something in writing, or you need to somehow document that there were no costs. And I can tell you from firsthand experience that there are certain clerks in the state of Georgia, it's like pulling teeth to get them to put on a piece of paper that to give you a zero bill of costs. But I strongly suggest that you get it so that $10 or $20 in cost doesn't crop up later and someone claim that your case wasn't properly refiled and it cost you your whole case. You must, of course, refile such case within 6 months if you intend to rely on the renewal statute to extend the statute of limitations. And finally, the renewal statute tolls the statute of limitations, but not the statute of repose. Okay? So in medical malpractice cases, you still only have 5 years from the date of the incident to bring a claim, or it's barred. So if you have an instance in which a lawyer took a couple of years, or you took a couple of years to pull together and file a medical malpractice case, you only have 3 more years in which to exercise your rights under the renewal statute, or you're violating the statute of repose. And I have had more than one case that arose from a lawyer properly exercising the right to renew under the renewal statute, but failing to realize that the case would nonetheless be barred by the statute of repose. Let's talk about dormancy in cases. It is more common than not that when I get cases, the most common cases involving missed deadlines or missed statutes of limitation, that those are cases that have just been dormant in a lawyer's caseload for a really long time. And oftentimes, it's true that perhaps those were not the greatest cases in that lawyer's caseload. But what many lawyers fail to do is to cull their cases and their caseload on a regular basis, to look at their cases and say, okay, I haven't gotten to that case in a year, or I haven't gotten to that case in 3 months, and I probably need to terminate the client or refer the case to someone who can get to it promptly. It's those dormant cases that languish in a lawyer's caseload that really pose the greatest risk of causing problems. And oftentimes, I think, lawyers are hesitant to dismiss clients when they should. And I think it comes from the right place. We want to do the right thing for the client. We want the client to have a good outcome. And so we don't want to withdraw without producing that good outcome for the client. But that is, like I say, a major source, those dormant, languishing cases of legal malpractice claims. With regard to dormancy, also bear in mind that if a case languishes in the courts for more than 5 years, it is automatically dismissed, and there is no remedy at all. It's irreversible after 5 years. This rule of professional conduct, 1.3, reminds us of our obligation to act with reasonable diligence and promptness in representing a client. And, we all work so hard, and we try our best to do that, but it never hurts to have a reminder that if you have clients to whom your service isn't reaching that level, it's probably time to cull your caseload and get it down to something that is manageable for you, and give the client an opportunity to pursue their case with a lawyer who can do so with reasonable diligence and promptness. And this is the statute, OCGA 9260, that provides for dismissal for want of prosecution after 5 years. If you're even approaching the 4-year mark in a filed case in which for any reason, including sometimes related litigation going on that's holding things up. Okay. If you have such a case, go ahead and get some kind of an order entered. The law provides that it can just be a status order. You can just have the judge literally enter an order that says the 5-year mark without an order is approaching in this case for the following reasons. This is a status order so that it is not dismissed by function of 9260. That's enough. But filing a leave of absence without the actual entry of a court order is not enough. And it's no surprise, I'm sure, that the very most common claim that I bring, not necessarily the most common that folks want me to bring, but the most common that I find to be viable and find to be a true claim, is a missed statute of limitations. There are a number of reasons for that. There are a number of ways that can happen, and it's not usually as simple as I had a 2-year statute of limitations and my lawyer missed it. We're probably all on top of our 2-year statutes of limitations. And I just remind you to calendar them and recalendar them. The trick is redundancy. The trick is obviousness, a very obvious place that your statutes of limitation are kept so that you see them regularly. But I'm sure you have all of that down. The most common reasons that I see for missed statutes of limitation in obvious cases have to do with life change. So a lawyer is going through something, be it a divorce, an illness, death in the family, and they lose track of their professional life for some period of time, and that can produce missed statutes of limitation that are obvious. But they should be obvious not only for the lawyer, but for the staff. So under those circumstances, staff also has an opportunity to help the lawyer be reminded of those approaching statutes of limitation. But be careful when you calendar a statute of limitations. And that, I think, is more important for just your day-to-day practice, and a risk that despite your best efforts and despite your being present and active fully in your office every day, missing a statute of limitations. In a car wreck case, be sure and compare the date that the client reports the incident with all the other records. That's not nearly as necessary when somebody comes to you promptly, but if they come to you a year later, you want to be sure and check that the date the client gives you is the date on the medical records, is the date on the police report, and that all the dates match. If there's one incorrect date in there, a client coming to you a year after the wreck can look at that incorrect date and report it to you, and the statute of limitations can wind up getting missed even if you checked the paperwork in one place. And I've even had clients call me, and I ask them, when did this occur? And they say, oh, this occurred in 2012. And they go on and on and on. Then they say, this occurred in 2011. You want to make sure that you're calendaring from the right date, because you sure don't want to rely on just a client recollection. And be mindful of the unusually short statutes of limitation for injuries to reputation is only 1 year. Foreign object left in the body is oftentimes only 1 year. There are a few unusually short statutes of limitation that you just want to know. You want to have them memorized for when they arise. Workers' comp can be a 1 year statute of limitations. Others can be 2 years. And always remember that loss of consortium can be 4 years. And that's an important one, because if somebody calls you after year 3, after a car wreck or some personal injury, you'd have the tendency to say, oh, you missed your statute of limitations. But maybe their spouse didn't. Maybe there's still a loss of consortium claim. You want to be very careful when advising people that they've missed their statute of limitations, because there are also any number of exceptions to the statute of limitations. And you actually have to have a lot of information to know if somebody's truly missed their statute. You have to know if they're a minor child, if they were incompetent, if there's an estate involved, if they're involved in a bankruptcy. These can all affect whether the statute has in fact run. So rather than telling people that the statute of limitations has run, if it's a case that I know almost immediately I will not be declining, maybe it's not in my practice area, etc., I will share with them what the statute is, 2 years, 4 years, and that it may be told for various reasons that they just need to get a lawyer as soon as possible if they're anywhere near the time period in which I believe the statute may pass, or if I believe it may have already passed. They need to have a thorough analysis of whether the statute of limitations has passed. The standard of care concerning the statute of limitations, in my opinion, can be violated not only by missing the statute of limitations, but by late withdrawal. This is a terrible problem in medical malpractice cases and other high-value, complex litigation. And it goes something like this. A lawyer who practices in securities, real estate, tax law, any field, stumbles into a situation where they have the opportunity to obtain a client who has a complex medical malpractice or other litigation matter that could potentially be big, big dollars. And for some reason, despite the fact that they have never handled a medical malpractice case, a personal injury case, they're not trial lawyers, they will sign that case up. And time again, I see them sit on it, or try to bring on co-counsel and they can't, or try to get an affidavit and they didn't even know how to get the medical records necessary to get an expert's review that would lead to an affidavit that would lead to the filing of this case. And 2 or 3 months before the statute runs, they give this complex medical malpractice case back to the client and say, I'm not going to be able to file suit for you. You're going to need to get another lawyer. Depending on when that withdrawal occurs, it can be too late. It can be a violation of the standard of care. It's not enough that you meet a statute of limitations. You have to give the client an opportunity to meet the statute of limitations. Returning a birth injury case file back to a client a month before the statute of limitations runs has effectively denied that client representation. It is not possible to get that case worked up. And there is no firm case law in Georgia that establishes for different kinds of cases how far in advance of the statute of limitations you must withdraw to avoid violating the standard of care. It's just not there. But I can tell you that the cases are out there that will create that law, and you don't want to be a part of that. So if you have cases where the statute of limitations is within even the next 6 months, if it's appearing that you may not be able to get the necessary affidavits or that you may not be able to file those cases for any reasons, I encourage you to go ahead and withdraw from the case. If possible, if you've had the case for a while, try to obtain another lawyer to take over the case. But withdraw and let the client know you're not filing this case and that you've been unable to work it up to the point that it can be filed. Another issue concerning the statute of limitations is unidentified claims. There are all sorts of claims that may be available to a claimant in what would otherwise be a simple personal injury case. For example, you take a third-party claim personal injury case, and there's also a workers' comp case there. Or you take a third-party personal injury case, and there's also a products liability case or a road defect case. And those all have different statutes of limitation and different ante litem notice requirements. So it's important to avoid any misunderstanding with the client about exactly what you're handling by being very specific in your fee agreement. And with regard to what you're representing the client on, that's generally something that's done case by case because you're inserting maybe in a form contract what it is you're representing them in, but you need to specify the kind of claim that you're representing them in, this kind of claim and only this kind of claim. But even that is not enough, because if you are taking a case based on a certain set of facts and you fail to advise the client of other remedies available to them, you've still violated the standard of care. So if you're taking something that appears to be a products liability claim and you have signed it up and even specified, I'm representing you in the products liability claim, but you fail to tell the client you also have a workers' comp claim, you violate the standard of care and you've technically missed a statute of limitations for that client. So you always want to be sure to examine all of your cases for other potential claims that may be out there or that they may have the potential to bring. This includes road defects, which I bring to your attention because they can have awfully short ante litem notice requirements. These are your ante litem notice requirements. Claims against counties, 12 months. Claims against cities, 6 months. Claims against the state, 12 months. Claims against MARTA, no ante litem requirement. Ante litem can be trickier than it looks. Of course, there are a lot of specifics required in an ante litem notice, and you can follow through the statute, and you can meet all of those. But the reason it can be trickier than it looks is because there are some entities that can require ante litem notice that it may not strike you at first that they would. Okay? So depending on the institution and the specific case law concerning them, you want to check for ante litem notice requirements against colleges, against hospitals, against hospital authorities, against the airport, against school districts, against bus companies. All of those you want to check for ante litem requirements if there's any chance that there's an ante litem requirement, because, of course, if you fail to serve ante litem notice, it acts like missing a statute of limitations and it forecloses your case altogether. Finally, if you make a mistake, if you commit malpractice despite your best efforts, it is, in my opinion, your ethical obligation to tell the client you have done so. The number one basis for punitive damage awards in legal malpractice cases is failure to inform the client that malpractice has been committed. This, of course, is the punitive damages statute, but the courts have held repeatedly that concealment by a lawyer of the commission of legal malpractice can be the basis for a punitive damages award against a lawyer. And folks, punitive damage awards aren't covered by your insurance anyway. So you really have an ethical obligation to tell the client. You also want to be sure that you have not concealed in any way the mistake you have made. My recommendation is that you tell the client face-to-face if possible, if not on the phone, but that you tell them verbally and then follow that up with a letter, because you do want a written record that you did inform them. But I find that clients handle that kind of information better when it comes in the form of a communication like a face-to-face meeting or a telephone call that says, I cared enough about the mistake I made to pick up the phone and let you know what I did. And then, in my opinion, you can try to fix your mistake. Now, at this point, you will have contacted your carrier. You will have told your carrier not that you have a claim, but that you have had an incident. Whatever that incident may be. Let's call it failure to file an answer. I failed to file an answer. I'm going to move to open the default. You need to call your carrier. Say, I think it's going to work out fine. I think the court will be with me on this. I think I'll be allowed to open the default, but I'm letting you know about this incident. I've advised my client, and you can go ahead and do that. There's no conflict of interest in continuing to represent a client after you've made a mistake if your interests, what you want to accomplish is the same as what the client wants to accomplish. They both want the default open, so there's no conflict of interest there. You cannot, however, start negotiating for a settlement, because that would be affected by the fact that there's a pending motion to open default. So you can't attempt a settlement during that time period that you're trying to correct your error, and it would reflect very, very poorly at trial if a lawyer committed a mistake and subsequently settled the case. But it also reflects poorly on a lawyer if they make a mistake and then try to withdraw from the case. And so many lawyers do that because they think they have to, because they think there's a conflict of interest. But it looks terrible. I made a mistake, and now you're on your own. And believe me, it only goes downhill from there, because no other lawyer wants to try to bail out that case generally. So I suggest you attempt to correct it. Consider employing your own personal counsel, not at great expense, not to do everything in your case, but in addition to your insurance defense counsel, you want a lawyer who's going to tell you if your carrier is acting in good faith, and you want a lawyer who's going to write that carrier a demand letter to take whatever action it is you deem appropriate if, in fact, you encounter problems with the carrier. You want the independent advice, many times, of your own personal counsel in a legal malpractice claim. And that, of course, does come out of your own pocket, but I think oftentimes that's money well spent. Finally, I just want to say that we are all human. We all make mistakes. The purpose of my presentation today has just been to share with you some of the knowledge I have the benefit of, because I get these calls every day, and I know the pitfalls that lawyers encounter. I hope I've given you some insight into that, not to cause you to be concerned about a legal malpractice case, but hopefully to cause you to avoid these mistakes for your clients and yourselves.
Thank you, Lindley.
Thank you.
Wait 1 second. Any questions?
Actually, I have a quick one.
Sure.
The side issue that you mentioned, the reservation of right letters that are sent in response to professional liability policy claims, and I was wondering, has an argument been made that crosses the line or toes the line into bad faith treatment of that carrier's client? Because I can think of a scenario where the reservation of rights letter wouldn't be appropriate because coverage and defense is completely clear.
I haven't had an opportunity yet to make that argument, but I'm actually expecting at some point that I will have a case where a reservation of rights letter has been inappropriately sent, where I will have an opportunity to prove that this carrier is sending reservation of rights letters in almost all of its cases, and I believe that will support a bad faith claim. That's a good question, Ashley.
Any other questions? I actually had one. So if you file suit against an entity and you dismiss for whatever reason, you refile, and then you discover you've sued the wrong entity through discovery or whatever, they tell you, well, it's actually this LLC, not us. What you're telling us is you cannot dismiss that case against that party because that would be a second dismissal on the facts, and instead you would need to add that party and then dismiss the initial party you sued.
Correct.
Okay.
Absolutely right.
All right. Thank you very much, Lindley. That's a great presentation. We're going to take a break now, and we'll come back after the break.